Good afternoon, everyone. Thank you for joining us. My name is Jeff Nolan. I'm a member of the advisory board for the University of Vermont's Continuing Distance Education's Legal Issues in Higher Education Conference. Welcome to the fifth in our series of 6 Legal Issues in Higher Education summer webinars. We're pleased to connect with you remotely and to be able to keep the conversation going about the new Title IX regulations. Today's topic is informal resolutions and restorative practices under the new Title IX regulations webinar, under the new Title IX regulations. We expect and hope for an engaging discussion today. Please post your questions to the chat for our expert panelists to discuss, and I will relay them to the panelists, and we really do want to encourage you to do that so we can have some interaction. I'd like to welcome the presenters. First is Megan Farrell. Megan is Title IX and Civil Rights Officer at the Palo Alto Unified School District. Welcome, Megan. Next, we have Chelsea Jacoby. Chelsea is the Title IX Coordinator at the College of New Jersey. Welcome, Chelsea. And then we have Carrie Landrum. Carrie is the Assistant Director of Adaptable Resolution Training and Strategic Partnerships in the Office of Student Conduct Resolution at the University of Michigan. So I understand, Megan, you're going to get us started. Please do.
Start off talking about informal resolution under Title IX with a particular focus on the new rules or new regulations under Title IX that were released in May and have an effective date of August 14th. And then we're going to talk specifically around restorative justice as an informal resolution method for Title IX matters. And we have 2 experts that are going to walk us through what exactly restorative justice is, how to use it in Title IX, and how 2 colleges are using it currently, and the success and challenges that they're facing with regard to that. At any time during this discussion, please feel free to put into the chat any questions you have, and we'll try to answer them contemporaneously with our discussion, but also at the end. Oh, shoot. Am I still muted?
Nope, we can hear you. You're fine.
Okay.
Go ahead, Megan.
Did you hear me from the beginning?
Almost
okay, good. All right. I saw a note that I was muted, and I thought I might have missed something. Anyway, back to this. So please post your questions contemporaneously while we're speaking. We'll try to answer them. But we will also have some time at the end to initiate and add some questions if you have any. So with that, I'm going to get started. So Title IX and the guidance that we've received from the Office for Civil Rights has flip-flopped over the years with regard to whether they like informal methods to deal with Title IX matters. So as far back as 1997, we see some OCR guidance that talks about the welcomeness of behavior and sexual harassment in schools, that when there is a power differential, so when we're talking about an employee harassing a student, a coach harassing a student, maybe a teacher harassing a student, that there is some level of power differential there that makes it difficult to utilize the informal method of mediation to resolve that matter. So there was concerns as far back as 1997 from the government's perspective around Title IX that there may be this power differential that could influence whether informal methods are really the best way to resolve these kinds of matters. That guidance in 1997 said it was not appropriate for a student who's complaining of harassment to be required to work out the problem directly with the individual that's harassing him or her. So the situation could be a power differential because of that employment situation, or just the fact that there's been a victim of harassment and a perpetrator of harassment. There might be some kind of power differential there with regard to social standing, with regard to age of students, that might influence whether that's really a good idea. In 1998 and 1999 is when we have our important case law decisions at the Supreme Court, first setting the deliberate indifference standard, and then talking about how individual students have a private right of action. In other words, saying that students can gain money if they sue under Title IX and deliberate indifference is proven. So all of that guidance was cautionary, I would say. in relation to whether mediation or some informal method of resolution was possible. So then we get to a real monumental change in Title IX enforcement at colleges and universities in 2011 with the guidance document that was issued from OCR that said, absolutely no mediation of Title IX matters. They didn't say it loud enough then, so in 2014 they issued other guidance that said absolutely no mediation of Title IX matters. So at that point we had a real red light on mediation. And I remember I was speaking on a panel with members of OCR right around 2014, and I heard for the first time that they were saying, we're talking specifically about mediation as the informal method that we are prohibiting, meaning that you could still solve matters and resolve these matters outside of mediation, but in an informal process. That was something that was said anecdotally at this meeting, and I think that for a number of practitioners, they were really enforcing this idea after 2011 that there could be no informal resolution. It had to go through a full investigation process. So we look at those two pieces of guidance, understanding that they have now been rescinded and were rescinded in 2017 with yet another guidance document, questions and answers on sexual misconduct in 2017 issued by OCR. And in that document, there was a specific statement that if parties consented, they could mediate. So then we come up to 2020 and the new rules on Title IX, where they say informal resolution is a possibility. So we now are at a point where we're looking at informal methods, not just mediation again, but any informal method of resolution being a possibility for schools. So the new rule does not require schools to adopt an informal method. So a college or university doesn't have to have an informal process out there. However, in light of the administrative burdens imposed under these new rules and these new regulations, it's really a good idea for your school to look into what informal methods and informal process they might have in place to avoid going through that investigation process, the hearing process, which can be both time-consuming and very costly. So it also provides some flexibility about who your facilitator can be in these new rules. It can be one person, you can have more than one person, or you can even outsource this informal resolution. So under the new guidance, the informal resolution is required under some specific set of circumstances. So first, and this is a key part of the guidance with regard to any investigation or any matter that you take on with regard to Title IX, a formal complaint has to be filed. So we need to have a formal complaint that is filed on behalf of the complainant. So if we learn about something, and I know this is something that I've done as a Title IX coordinator, when we learn about something but we hadn't yet received a complaint, we would often look into informal methods. The guidance is now saying you have to have that formal complaint. This is not in my notes, but I would ask you to add it to it. So not only do you need that formal complaint filed, but you need to advise the responding party of what allegations that person is facing. So the notice of allegation should have been issued to the responding party. So both the complainant has articulated exactly what they want to be investigated or at least to be resolved, and the respondent is responding to looking at what allegations have been brought against him or her. So what you need to do other than having that formal process and offering the notice of allegations is make sure that you provide both parties with a description of exactly what your informal process looks like. The parties have to agree to that, and they want to agree to that in writing. So this is a documentation piece to make sure you keep proper documentation of this. And you can't require anybody to participate in your informal process unless, and make it dependent upon whether they can stay enrolled. So we can't really twist the arms of either party to say you have to participate in this informal process, or you can't remain a student, you can't remain on a team, you can't remain in this course of study, for instance. So you have to make sure it's really voluntary. And both parties are permitted to stop it at any time and go to the formal process if they are unhappy with how things are progressing at any point before you reach that resolution. So if you haven't had a signed resolution, either party can opt out. One important provision in these new rules is that informal resolution is never permitted if you have allegations of sexual harassment and the complaining party is a student and the responding party is an employee. So back again to that idea of a power differential, we never really want to present students with a situation where they are responding to an employee in an informal resolution process. It's important to keep in mind anybody that you have in that informal resolution process, there aren't that many requirements under the regs, but they are requiring you to make sure that anybody that facilitates that process for you has training. They have training around what the definition of sexual harassment is, around the jurisdictional requirements of sexual harassment under these new rules, and also how to conduct that informal investigation process. Something that's big across the rules and certainly in this informal resolution part is that you need to make sure that those facilitators are avoiding bias, conflicts of interest, and that they're serving impartially. So as I mentioned, mediation was a type of informal resolution that's been mentioned in guidance from OCR for many years. What the whole umbrella of informal resolution includes a lot of different things. So as you look at what processes there might be, you might have an arbitration process, a mediation process, some facilitated negotiation process, and then, of course, restorative justice is just one of the methods you might utilize in your informal process. Restorative justice is a theory of justice that emphasizes repairing the harm caused by negative behavior. So that's just one description, short description of what restorative justice is. And I noticed that we have one question that I just want to answer before I turn things over to our restorative justice experts. Would you have a description of the informal resolution process in the notices to parties? I would say that you want to do your notice of allegations as one kind of document that mentions that informal process, but I would have my informal process sort of as an attachment to that letter so that I could have it available for everyone. So I wouldn't want it to necessarily embed it in that notice of allegations, but I would include it. So here's our informal resolution process. The reason why I like that document to be an independent paper or document is because then we bring that to the informal process and we have it sitting there with us. And we say, hey, here are the rules of our informal resolution process. So you can embed it in your notice. You certainly want to embed the option of using informal resolution, but sort of the details of that, I would say put it on a separate letter. And then I'm going to now turn it over to our other experts who will give you their opinion on that as well. So with that, I'm going to turn things over to Carrie.
Thank you, Megan. Can you hear me okay?
I can hear you.
Yep, go ahead.
Great. So it's my job here to share an overview of restorative justice, recognizing that everybody who's tuning in may not understand, or have a full comprehension about restorative justice. So first, I wanted to share that it's both a theory and a set of practices. It's also known as restorative practices. It's a theory of justice that's relational rather than punitive or retributive. So it centers people and relationship and the harm and effects of wrongs on relationships at all levels, whether individual or group or even the community. It's also a worldview and even a way of engagement. Some people do use the term restorative justice or restorative practices loosely to define an alternative process for doing justice, like, for example, informal resolution. But these practices may not necessarily reflect restorative principles, and to the extent that that's the case, they would not actually be restorative. I wanted to share a little bit about the historical origins and roots of restorative practices in Indigenous peacemaking and also victim offender mediation. So restorative justice, or RJ, is a modern term that just came into fashion in the last few decades, but the principles and relational forms of justice and peacemaking that they represent and need to embody are actually time immemorial as long as humanity has been living in community. Restorative justice is rooted in Indigenous peacemaking practices across the globe, particularly Native American and First Nations people of this continent, including the Anishinaabeg, who stewarded the land I'm currently on in Michigami, as the Ojibwe named Michigan, and also especially the Navajo or Diné people and other tribes of the Southwest. Other known Indigenous roots include the Maori, who brought family group conferencing across all of New Zealand and beyond, Polynesian communities that practice ho'oponopono, and African cultures such as those in Sierra Leone, who gather in circles to use fambul talk, which is Creole for family talk, to address and heal significant wounds from their brutal civil war. More recently in North America, victim offender mediation or victim offender reconciliation programs that began in Canada in the 1970s paved the way for alternative dispute resolution and restorative justice practices to be implemented, particularly in partnership with court systems. Now, restorative justice is gaining widespread popularity and adoption across the continent and beyond, especially in schools and educational institutions as we return to Indigenous practices of peacemaking. At U of M, we've been incorporating restorative practices into our student conduct work since at least 2007, and specifically into our section with conduct policies since 2013. So the purpose of restorative justice is to collaboratively and inclusively address and repair harm to make things right. One way to think about restorative justice is contrasting it with criminal justice. And in criminal justice, the focus tends to be on questions of what rule or law or policy was broken, who broke it, and what should we do to them, or how should we punish them. It's very individualistic, and it's focused on institutional power imposing blame and punishment. Restorative justice, in contrast, focuses on the questions of who was harmed, how are they harmed, and how can that harm be repaired. How do we make things right, and whose responsibility is it to do that? We do this through collaborative and inclusive processes that invite everyone who is involved to come together to figure that out through a process of consensus. The goal in restorative practices is to address harms and causes of harms by centering those who were harmed. So we know victims don't often get to use their voice in a court or even in some student conduct processes, and they don't get a say in what happens. Restorative justice centers harmed parties by exploring how they were impacted by the harm and what their resulting unmet needs are. So RJ seeks to find ways that those harms can be repaired, and the harmed parties not only get a say, they literally get to determine what happens through a consensus process. And of course, making things right requires that we address not just the harms, but the causes of those harms. In the restorative adaptable resolution processes that I facilitate, the #1 most requested outcome by those who were harmed is that the student respondent, or the person who caused the harm, complete education related to sexual misconduct. This is what student survivors ask for because it addresses the cause of the harm and helps ensure that it doesn't happen again. The process of restorative justice invites those who were harmed into an exploration of harm, repair, and responsibility. I say those who were harmed, I mean those who were involved, because it includes the harmed party and the student who caused the harm, and can also include other members of the community who were involved or impacted. So the circle of impact can widen beyond just the respondent and the claimant. So unlike hearing processes, which can encourage the hiding of truth and the avoidance of responsibility, restorative justice requires by definition that the person who caused the harm is willing to take responsibility for repairing the harm, and usually also requires them to take responsibility for having caused that harm. At the University of Michigan, our sexual misconduct policy describes adaptable resolution as, and I quote from our policy, generally designed to allow a respondent to acknowledge harm and accept responsibility for repairing harm to the extent possible experienced by the claimant and or the university community. Additionally, accountability by those who caused harm is a key component of restorative justice, and this is one thing that makes it distinct from mediation. So when the Department of Education was saying no mediation, we at U of M interpreted that, well, what we're doing is restorative practices, and that's different from mediation. So in mediation, typically the people involved are referred to as disputants, and there's an assumption in mediation that the disputant's claims are equally valid. Additionally, each party is often expected to compromise and give a little to find some kind of solution. But in restorative justice, there are distinct roles of the participants. One is a person who experienced harm or wrongdoing, and the other is a person who is taking responsibility for having caused or contributed to that harm or wrongdoing. It's then the responsibility of the wrongdoer to repair harm to the person or people who are harmed. And restorative justice additionally incorporates the theory of justice mentioned earlier and the related set of values. These values include, and are not limited to, interconnectedness, particularity, respect, support, accountability, agency, choice, and voice, and even healing and wholeness. I say interconnectedness because we are all caught up in a web of relationships, and a college campus in particular has a very complicated and tight web of relationships, and this definitely impacts the cases I see in adaptable resolution. And I mentioned particularity. because it relates to individuality. Every person's vision of justice or putting things right may look different, and so the solution ought to be unique to that person. Some conduct processes assume that X violation should equal Y sanction or outcome, but RJ simply seeks to meet the needs of the person who is harmed, and that could look like a variety of different things. A fundamental part of restorative justice is respect, and this is respect for everyone who is involved, the person who is harmed as well as the wrongdoer. Most RJ practitioners stay away from words like offender because it can serve to dehumanize a person, and it's imperative in RJ that everyone is treated with dignity and respect. This is key because treating people respectfully encourages and allows them to take accountability and to learn from the process and to be better. Another common way of thinking about RJ is thinking about it as equitably balancing support and accountability. Criminal systems in our country tend to be extremely punitive and high on control and accountability, with little to no support for actually transforming or quote-unquote rehabilitating someone, but RJ has a lot more success and effectiveness in producing transformative outcomes for everyone involved. And then we have agency, choice, and voice, which of course those in survivor or victim advocacy work know is essential to offer to those trying to heal from harm. And agency, choice, and voice is also important and helpful for the wrongdoer or respondent as well in taking accountability. And some additional values include empowerment, healing, and wholeness that are often incorporated into RJ. So why might we want to use restorative justice on a college campus? Well, to begin with, they're rehumanizing. They're humanizing processes for all parties involved. They're also person-centered or student-centered, and of course, student affairs professionals and universities ought to be student-centered. And there's no more student-centered process than restorative justice, as it literally centers the student who experienced the harm and the student who caused the harm to come together and for them to figure out how to address and repair the situation. It also acknowledges that our students are learners and developing humans. Their brains are literally still developing in most cases, and we can help them learn how to do better. Just like when Maya Angelou said, do the best you can until you know better. Then when you know better, you do better. And students learn more through RJ than they usually do in a hearing process. As I mentioned before, it allows for support and accountability, and like challenge and support, this process really helps students to be reflective learners, and the support allows them to grow and learn from the process itself and the experience. It also addresses harms and their causes. So by addressing causes of harms, it promotes safety and it promotes learning. We're making our campuses more safe when we address these causes of harm. And of course, it gives students and survivors more control over process and outcome and gives agency, choice, and voice, as I mentioned. And hearings don't allow agency, voice, and choice in terms of process and outcome, right? Because a third party is making the decision on outcome. And we know that these things are critical, particularly when working with survivors of sexual violence. So restorative justice can help address those agency needs and empowerment needs. The process also allows for creativity and creative processes and solutions that are tailored and individualized. And as I mentioned before, restorative justice is a relational justice. And we know that sexual misconduct tends to be a relational harm. It's often happening between students who are in a consenting romantic or sexual relationship, and that's certainly been the case in many of the cases that I've facilitated. And where that's not true, the students are usually in other types of relationships, like being roommates or classmates, or they're in the same student organization, or they're in the same living and learning community, or the same academic program. And especially when they're in long-term relationships like the same PhD program where they're in it for years together, it's really helpful to have matters addressed using a relational form of justice. And then, as Chelsea will talk more about, it is less time and resource intensive than investigative resolution to use informal processes and to use restorative justice. One of my favorite reasons for employing restorative practices is that it's not trauma inducing, and it may in fact be trauma healing. We know that sexual misconduct proceedings on college campuses often cause harm and are trauma inducing themselves. I've heard many student survivors who've gone through these processes across the nation have said that the process itself, the hearing process, was more harming to them than the original incident of misconduct, which is pretty messed up in my opinion. So restorative justice is trauma-informed and trauma healing, and trauma by definition comes from the Greek word traumat, which means to wound. And so restorative justice specifically attends to harms and wounds, and so it's trauma-informed and it's trauma healing. By the way, trauma-informed care realizes, recognizes, and responds to trauma and seeks to resist or prevent re-traumatization, and restorative justice does this. It also creates the space and conditions for true justice and healing. It encourages and promotes personal transformation and growth, which hearings are unlikely to do. And it allows for a focus on learning, as mentioned previously. So, of course, we're all educational institutions. We should be utilizing processes and theories of justice that are supportive of learning. And the fundamental principle of restorative practices, per the International Institute for Restorative Practices, is that human beings are happier, more cooperative and productive, and more likely to make positive changes in their behavior when those in positions of authority do things with them rather than to them or for them. And restorative practices are a process that engages with students and doesn't impose sanctions or impose punishment to them or for them. And so that's restorative justice. And I'll get into a little bit about how we use restorative justice in adaptable resolution. So there is a little chart there, or table, that some students put together in our student university newspaper, the Michigan Daily. And it shows how we've been using adaptable resolution under various names since 2013, because we interpreted that while the Department of Education was prohibiting mediation, they weren't specific about restorative justice. And we recognized some key differences, as I spoke a little bit about previously, between restorative justice and mediation. So we did allow some forms of what we originally called informal resolution in 2013. Now, these were not for cases of sexual assault. These were only for cases of sexual harassment. And then in 2016, we changed the term to alternative resolution. And then in 2019, when we got the green light to go ahead and use these for sexual assault cases, and it allowed us to use restorative practices, we incorporated that into our current interim student sexual misconduct policy that went into effect in January of 2019. And you can see there at the bottom that we have a description about what adaptable resolution is. It's a voluntary, remedies-based, structured process that allows the parties in a Title IX process to agree to a resolution without formally disciplinary action against the respondent. Adaptable resolution is generally designed to allow respondent to acknowledge harm and accept responsibility for repairing harm, as I mentioned earlier, to the extent possible experienced by the claimant and/or the university community. In our policy, there are 4 different ways that one could go through adaptable resolution. So it may include one or more of the following restorative approaches, which includes facilitated dialogue, restorative circles or conferences, shuttle negotiation, and circles of accountability. So facilitated dialogues are exactly what they say they are. 2 people are having a conversation about something. Some understanding is up to them what they want to talk about, and we can facilitate it as part of our informal resolution, or adaptable resolution rather. Restorative circles or conferences are 2 distinct forms of way restorative justice are practiced. I won't go into those now. The differences between them, basically one uses a script and one uses a talking piece, are the main differences. And so we have that as a process, but many students do that in addition to a shuttle negotiation process. So this is the type of negotiated resolution that Megan mentioned earlier. So a facilitator will go back and forth between the parties to come to the terms of a written agreement, what the respondent usually agrees to do these things. And so that can happen without a face-to-face encounter in a restorative process, or it can happen in conjunction with a face-to-face encounter in a restorative process. And at the University of Michigan, most students going through adaptable resolution are requesting that shuttle negotiation. They have an idea of what they would like the respondent to do. As I mentioned earlier, that's education. And they don't necessarily want to meet with the respondent face-to-face. The circle of accountability really takes the process more out of the hands of the parties, and they say, look, I didn't want to go through a hearing, but I really want this to be addressed, but I don't really want anything to do with that process. Can you, institution, just handle that? And then basically the institution will engage in restorative practices through a circle of accountability and maybe ongoing meetings to address what happened. Actually, no students have requested that process because they actually want a voice and choice and agency in the process and in the outcome. And facilitated dialogue of processes, again, sometimes in conjunction with the shuttle negotiation. And I would just like to clarify that for adaptable resolution to be viable, the claimant has to request it. So it doesn't happen when a respondent requests it. The Title IX coordinator has to approve it in terms of she gets to say whether or not it's a viable option. And then they have to go through preparatory meetings with the adaptable resolution coordinator, and then they can leave the process at any time up to the point of a negotiated resolution or an actual resolution agreement. All processes that conclude an adaptable resolution do conclude with a written agreement. They do, of course, per the regs that Megan talked about, have to sign a written participation agreement. It clarifies confidentiality. I can go over the details of that later if that's of interest. And then they need to, basically the parties will need to decide together through consensus which of these processes they want to go through. Sometimes a respondent wants a face-to-face process, for example, and a claimant doesn't. And so I help them figure out what process they're all going to be agreeable to do, which usually favors what the claimant is asking. And then if they are in agreement voluntarily with the agreement or with what's been requested, then they can both voluntarily sign a negotiated agreement. We call it a resolution agreement, and that meets the needs of the claimant and the university community. That's an overview, and I'll pass it over to Chelsea.
Carrie, would it be okay if I ask a couple questions? So
yeah, go for it.
When we're thinking about educational opportunities offered to those who cause harm, this is posed from our participants, are those often offered one-on-one predominantly, or are there other ways that that's done?
The educational opportunities for those who cause the harm? Yeah, we do those one-on-one, and I'd like to give a shout out to my colleague Jim McEvely, who runs our program. We call it STARSA. It stands for something long that I can never remember, but it's about strategies to reduce risk. And it's a one-on-one tailored program. Students meet for an hour with the facilitator, and they do that regularly, like every week, for the number of times that the facilitator determines is appropriate. Usually it's on average between 8 to 12 sessions. They're, again, 1 hour, one-on-one tailored. It's a really great program, and I've heard basically every feedback I've heard from respondents about it says it's a valuable opportunity, that they appreciated the learning, that they felt treated with respect and dignity, that it was a good use of their time, and they describe Jim in particular as fantastic to work with. And so you have a respondent who's not gone through a hearing in the cases that I'm thinking about, but they do also go through these as sanctions. So they're not necessarily jumping to sign up for this, although some do. Some claimants even voluntarily sign up for it. Some respondents voluntarily sign up for it before they're even required to, or before they sign a written agreement saying that they will. And they do find the process valuable, and it's definitely one-on-one. That's the way to help ensure true learning and transformation.
Okay. And another question that's been posed, in what ways does your office or your function at the university partner with individuals responsible for sexual violence prevention on campus, if you do?
So we have a sexual assault prevention and awareness center on campus. They have survivor advocates. Those advocates sometimes accompany students into our meetings. We have intake meetings with students, whether they're going through a hearing or adaptable resolution. Some of my adaptable resolution preparatory meetings include survivor advocates in the process. I had a case this summer where I reached out to survivor advocate to make sure that I had a request from a claimant that I wanted, from the respondent rather, that I wanted to communicate to a claimant, and I wanted to ensure that my request didn't negatively impact that claimant. And so I reached out to the survivor advocate separately, who had, the student had given written consent for us to share that information with the advocate. And I worked with that advocate to ensure that we are basically, that I was engaging in a trauma-informed way with the claimant as I shared information that was requested to be shared by the respondent.
Great. Now, one of our participants heard you mention what they thought was maybe a national organization, like a certifying agency for restorative justice. Is that something that you meant to say?
I did make a brief reference to the International Institute for Restorative Practices. They do offer some certification in restorative justice. So for those who are looking for education, that is one way to do that. I also want to give a shout out to PRISM, which is part of an RJ program out of the University of San Diego. And so they offer some restorative justice trainings, and they have a group of administrators at colleges and universities who are interested or starting to implement informal resolution or specifically restorative justice for cases of sexual assault on a college campus. So PRISM, PRISM, stands for Promoting Restorative Initiatives for Sexual Misconduct on College Campuses, and there's a website, and I encourage folks to check out that website and those training opportunities.
Terrific, thank you. So we have another question about process issues, but I'm going to hold that one until after we hear from Chelsea, because it's probably more in Megan's bailiwick. But so go ahead. Thanks for clarifying. And there we go. Oh, it's Chelsea's slide. Perfect.
Ooh.
Perfect segue.
Can you hear me?
We can. Thank
Okay,
you.
great. Good afternoon, everyone. I appreciate Megan and Carrie providing kind of the foundation for kind of how we got here within the Title IX realm and then what it looks like with implementing RJ itself. And so I want to talk a little bit more in addition to what Carrie provided about kind of the boots on the ground and what this looks like in practice. And so similar to kind of the trajectory at University of Michigan that Carrie had been explaining, at the College of New Jersey, prior to 2017, the former Title IX coordinator had started to kind of see this trend where students would consistently report and express that, look, I'm not interested in getting this person in trouble. I simply just want, one, to receive resources, but I want the student to understand the impact their behavior has had on me, change that behavior, and then not engage in it again moving forward. And so this had been kind of a consistent pattern, which we are still seeing to this day, but that kind of prompted us to look at the policy and understand, recognize that we had gaps within our resolution options, that we had a process, specifically our formal administrative hearing, which, as Carrie mentioned, is not looking about what harm had been caused, but rather what had happened and was there a policy violation and should punitive outcomes be implemented. And it really doesn't look to repair any harm that's been caused or experienced. And so the previous Title IX coordinator dove into looking at forms of research and reviewing current practices. And there were not at the time a lot of institutions who were implementing these practices. And so really was kind of taking the foundations of restorative justice and applying it in a setting that worked with our student needs and within the confines of the educational community. And so from there, kind of that needs assessment was done, and I'll tie in that a little bit more for those who are looking to implement these processes, figuring out what your campus needs and what that looks like, and then how we can create processes to address those and meet them. And so that was conducted, and a policy had been drafted, and it was formally implemented in our Title IX policy in 2017 to be able to utilize our alternative resolution process for cases involving sexual misconduct. And so from there, we kind of kickstarted a bunch of trainings for staff to help implement these processes. I'm definitely going to give a shout out to Campus Prism, as Carrie mentioned, as we've done a lot of our trainings with them specifically to really kind of create that foundation and applicability. And we've also engaged in a lot of targeting and or targeted marketing, so our campus knew about these resolution options. It's really great that you offer them, but if no one knows about it, they may be not reporting because they don't know this option is available and thinking that they must have to go through a formal process when there are alternative other options. And then you'll notice 2018, 19, and 20, so essentially every single year, we've updated our policy for one reason or another. But I preface that because through this, you learn a lot about implementing and what's working and what's not, and every single case is different. And so I can't stress enough that for practitioners or college administrators who are looking to implement this, be ready and willing to change, be ready to adapt and evolve, because the same way that our students' needs are going to be individualized and evolving, our processes need to be doing the same thing to meet those needs. And so ultimately, from between 2017 to 2020, we've had 22 cases who had expressed interest in using our alternative resolution process. And so I want to kind of dive into a little bit of what those look like. Within those 22, 14 have been completed. And so they've gone through the entire process, and I'll walk through a little bit what that looks like. 3 cases that the reporter, which is the term that we use in lieu of victim or survivor, in those cases where the reporter had requested to use this process, 3 of them the college had denied. The instances where we would typically do that are, one, if we're looking at a case involving a repeat respondent, if perhaps there had been egregious bodily harm or a weapon used where perhaps they may cause a greater threat to the campus community, and in instances where the harmed party is a minor or there may be active or ongoing child abuse. Those are kind of our 4 main buckets that we would say at the college, let's take a look at this to see if this is appropriate. Each one is evaluated on a case-by-case basis, but that's kind of our foundations of where we'll start with. There were 3 cases where the respondent had denied. 1 had preferred to use a formal process, and other 2 had kind of expressed that given the previous relationship they'd had with the reporter, like we've talked about this before, I thought that this was resolved. I really don't want to rehash all of this again and move forward. And then two, the reporter changed their mind. And so I think these are equally as important to consider as our 14 other completed cases, where in this situation, one of them had decided to go through with a formal process, but one in particular had worked with us to create the entire contract, which I'll explain in a moment, exactly what they felt like they needed the respondent to hear, see, complete, and engage in to repair that harm. And just before we were going to reach out to contact the respondent and request an opportunity to meet, the reporter had actually seen them that weekend, sat down, and was able to have an entire dialogue with the respondent. And she reached out and was like, I don't need you to do this anymore. You know, I felt empowered to kind of do this on my own. I knew what I needed. I knew what I could say. And I feel like I'm in a good place now that this is exactly what I wanted. And so even just kind of going through the steps of identifying for the student themselves of how perhaps they have experienced harm, what that looks like for them and what they might need to repair, that can also be a part of that healing journey as well. And so I wanted to talk a little bit about our process itself, and it's very similar to that of the University of Michigan, as Carrie explained before, with their adaptable resolution. But for incidents that are reported to the Office of Title IX, we go over with the reporter all of their rights, resources, and available resolution options. And should they express interest in the alternative resolution process, we'll talk through specifically, similar as I mentioned before, what would the respondent need to hear, see, complete, or engage in to recognize the harm that's been caused, identify the impact that that's had, as that's typically the greatest request that we're hearing from reporters, of the other person wanting them to recognize the impact that that's had. Commonly we hear, you know, it's not fair that this happened to me, and then they get to walk around on campus and nothing has changed in their life when everything has changed for me, and I want them to know that. And so we kind of talk through what this would have to kind of consist of. Oftentimes this uses the Shuttle Negotiation process, where we help craft that educational contract, which is then I will outreach to the respondent once the reporter approves the contract is good to go. And to kind of go along with what Megan said, I want to share another alternative to that perspective for the notice. At the College of New Jersey, currently, and however, with what Megan shared, perhaps we may want to reevaluate in certain circumstances now under the new regulations. But previously, what we had done is that outreach to respondent was simply, these are the allegations we received, right? Date, time, brief description. At this time, although this may constitute a possible policy violation, the reporter has requested interest in utilizing our alternative resolution process, which is brief description. Therefore, at this point, we will not be using any formal process. However, should that change, you will receive updated notice and new notification of what that process would entail. And so ours are kind of combined, but it doesn't have the specific details of what their particular alternative resolution contract would look like, just more general. So some of the things that are typically included on this contract, I've listed here. Our two most common educational activities and restorative practices that are included on here is the salient analysis of interpersonal dynamics, which is a mouthful. So that's our SED workshop, and our impact statements. So those SED workshops were created specifically and internally at the College of New Jersey by myself and my colleague, Zach Gall, who is in our anti-violence initiatives. He's a counselor for victim advocates. And he was helping facilitate a lot of these workshops that were more informal, for lack of better words, and talking about what is consent, what do we know about it, how can we make sure that we're not kind of engaging in behaviors that led to us getting to this place initially. And so we both felt like it was important for us to really kind of firm up that process and make that more solidified. And so we've standardized this in a way that still allows for flexibility, but we've created workshops that were 3 sessions, 1 hour apiece, that really focus on rapport building, critical thinking, analysis of different situations, scenarios, self-reflection, and kind of engagement in that facilitated dialogue. If the reporter also includes an impact statement on this contract, we have a section specifically built out in the SED workshop for that impact statement to be shared, to allow for a debriefing session with the respondent as well. A lot of focus on these processes are on the reporter, and as they should be. As Carrie's mentioned, for RJ, we need to center the person who's been harmed. But at the same time, particularly if these processes are facilitated through our Title IX office or any other kind of name, but in the same capacity, It's important to recognize that we need to support both students as well, and we have to do that equitably, which means that it might look different for both. So at the very least, when we're sharing that impact statement, we don't want to just leave them hanging, right? And perhaps recognizing the first time that someone may have felt they engaged in this behavior, or that they've ultimately changed someone's life in the way that they have, we want to be able to offer that debriefing session in addition to that. These are supposed to be as individualized as possible. And so perhaps if the party had been intoxicated or arguably incapacitated, perhaps they want the respondent to engage in an alcohol workshop where they learn about the ability to provide and receive consent when consuming alcohol or their drugs, when is kind of that fine line when someone is able to and when they're not. Perhaps they were interested in the other party understanding why perhaps they weren't acting, quote unquote, the way in which they would have imagined of someone being harmed. And we talk a lot about that neurobiology of the body in terms of trauma and harm, and perhaps the way in which we're communicating or reacting doesn't actually reflect what's internally going on due to that trauma. And again, this could be as unique depending on the situation as possible, and as it should, to be able to try and address the harm that that individual student had experienced. And so ultimately, to kind of craft this contract and facilitate this process, as Carrie mentioned, there's a lot less burden administratively on the institution when we look at kind of comparing our formal investigation process compared to our alternative resolution. We had a rough estimate of about 76.5 hours that are spent administratively implementing our formal resolution processes, from initial notice to interviews, compiling investigation reports, and so forth, as opposed to 25.5 hours for facilitating an alternative resolution process, with the caveat that, again, every process will look a little bit different, but the administrative burden on the back end to help facilitate that is much less. And so I know that there are oftentimes concerns of how do we generate buy-in, right? A school might be really interested in doing this, but they're getting pushback from their campus or perhaps general counsel of maybe this isn't the right way to go. And so some of the kind of numbers of, when we're talking about staffing, there's also, I can't do this because I don't have enough staff. Well, it'll probably take you less time and administrative, requirements to facilitate these processes than our formals. Also, the litigation risk, and I'll have Megan talk a little bit more about that if there's time at the end, but for two people who are voluntarily agreeing to participate in this process and have that say of what they're willing to engage in or not, the possibility of perhaps someone suing for using an alternative resolution process might be very much less than that of our formal process, where again, those outcomes are imposed on someone without their decision or input. And so when we're looking at those pieces, that might be a way to kind of communicate that with our campus as well, with the most important reason being that this is requested by students. This is, at least on our campuses, as Carrie mentioned, both for University of Michigan and TCNJ, where they were looking for something else that we weren't offering. And when we're looking at the new regulations, the requirements basically in terms of the use of advisors, the cross-examination, the consideration of information, essentially requiring participation at a hearing in order for their participation to matter, there are a lot of obstacles that might keep people from wanting to engage in a process if that's the only one available. And so meeting the student need is obviously one of the major benefits of that. And I want to highlight some of the experiences in particular for students who have gone through our process. And so this is feedback specifically from reporters who have used our alternative resolution process and provided feedback at the end. And I've highlighted some little nuggets. Well, all of it is great, but I want to draw attention to some major pieces where one individual had shared, like they wanted a different way to hold someone accountable, right? Every single instance of sexual misconduct or violence is going to be different, and parties are going to have individual needs. To imagine that we have one resolution process that would meet the needs for every single party, such as our formal process, is completely unrealistic. And accountability looks very different for every party. And so recognizing that we're giving a platform for that to be achieved. And just a feeling of empowerment. One student said, this process allowed me to have a voice. Right? It gave me the opportunity to make a direct impact statement to my abuser where I could express all of those thoughts I wish I had said to him sooner after he hit me. It was definitely not easy, but I finally got the closure I needed, and it allowed me to feel empowered. Right? I wanted them to reflect and possibly engage in behavior change. And now I feel at peace. Right? And so those are powerful kind of read in terms of a reporter's experience, but equally as so from that of our respondents. As Carrie mentioned, that the greatest way to start to enact behavior change is to engage the parties in that process, but also really focus on the education. And so when we look at some of the feedback from our respondents who participated, many of which in those workshops and receiving of an impact statement, they expressed that the process felt validating, right? They felt that they were able to relate a lot to what happened in their own relationships and their own situations through those dialogues. They were surprised at how relatable that learning experience was, right? And feeling that they're not alone in perhaps some of the initial thought processes or perceptions that go along with consent and all of those gray areas along the way. They found it incredibly beneficial and helpful, an overall positive experience. And to be able to see for a respondent's perspective, one had shared, it was very important to me that I grew and learned my lessons so I can make better decisions in the future. To be able to offer that opportunity within a formal process, I don't want to say it's impossible, but our formal processes, the respondent only has the chance to learn the impact for the reporter truly if they are found responsible. And that does not necessarily mean that the behavior didn't occur, but rather there wasn't enough for a finding of responsibility. And so they may leave and not understanding, even if not responsible, the impact that they may have had on that other party. And tying into that last piece, one person shared after hearing an impact statement where they had identified the respondent as a rapist, right? I was raped. And they had said that the hardest thing for them to read was her using that word. And they had shared, I think she chose that word because of the impact that it's had on her life, right? And so we can see these opportunities for growth and learning and development. And I can't emphasize enough the importance of focusing on the educational and restorative options that you would offer within your wheelhouse and your resources to be able to utilize these processes. It's great to have it in a process and a policy, but if you don't have anything to help carry that out, it's really going to be unfulfilling for both parties and not really address the harm that it was intended to do, and perhaps it may actually create or cause more harm. So the last little pieces in terms of lessons learned is be brave and go all in, but don't rush it, right? August 14th is 1 week away. I know those of us since May 6th have had a countdown, and now we're in single digits, and it's incredibly real. If you don't have these processes in place at this current moment, the ability to probably implement that in the next week is going to be very, very challenging. And so understand that it needs to be intentional and considering the long game of different situations that you may account for, and if your policy can accompany that as well as your resources. You need to dedicate a lot of time and intentionality to creating advantageous learning environments, because that is where that behavior change and reflection and learning will come along with that healing and repair. And you need to have set standards that will help guide decision making of when you're using these processes and when you're not. Similar to our formal process, we have situations where it's required and not. The same thing, we have to kind of have those frameworks for our own selves of when deciding whether to approve the use of a process or not, such as, is someone going to participate in good faith, right? Have they already engaged in this process? Has it worked? Do we want to do this again? And what harm might come from one way or another? And then being comfortable with change, right? Making updates after every few cases, whether it's your internal operating procedures or your policy at large, but recognizing that even though you have it solidified, there will always be room for things to adapt and evolve, and just being okay to do that.
Terrific, Chelsea. Thank you so much. As we transition into a few minutes for questions, I'll just note in passing, as Chelsea just noted, we only have a few days left before our policies need to be publishable. Just remember that, as indicated, you don't have to have your entire informal resolution process built out if that's not something you have currently established. You can refer to the regulatory language, which notes that you will have a process. It will be prefaced by certain notices that you have to give, as I think Megan referred to, and that's what will happen if we're going to engage in that. But you don't have to have all the details fleshed out at this point, because those are probably going to change as we learn more. As Carrie said, as we learn more, we do better. We have several great questions and terrific ones. We probably won't get to all of them, but I will start with one that came in quite early. I think I'll pose this one to Megan. Do you recommend that any information revealed in restorative justice or mediation remain confidential, or that it shouldn't be used in an investigation internally if RJ falls apart?
Jeff, thanks. This is a great question. First, I will mention that the regulations talk about your facilitator and whether that facilitator may later be a witness in a hearing if your process falls apart. And the regulations are permissive in the sense that they say you can allow that person to be called as a witness, but it's also permissive that you can say that in your process that you won't. So I would say, just like in the court system, when you're engaged in some kind of informal resolution process, that's normally not admissible when you go to court. I would say for those same exact reasons, which are you want that process to be open, you want that process to get as far as it can, that you really wouldn't want to have your facilitator come in or to reveal all that information in the process when you come to a formal hearing. So I would say your informal process and your hearing process should both note that you're not going to discuss what happened in an informal process, and maybe even go so far as to say you're not bringing facilitators in as witnesses. A lot of times in RJ processes, we're looking for the harm to be acknowledged, some sort of apology for that harm rather than the behavior, because there may be discrepancy about the behavior. So I would try my best to keep that information out.
Thank you. There's a question about terminology. The person asks, if colleges use the David Karp RJ term active accountability versus responsible, can that be done? There's a concern that the responsible sounds more like a policy violation.
I can jump in there.
So I can speak to that. I know I have many respondents who ask me, by signing this participation agreement or by signing the resolution agreement, am I admitting that I engaged in this behavior? Am I admitting that I engaged in a policy violation? And in fact, they are not admitting to a policy violation, and they're not even admitting that they caused a harm. Restorative practices generally require that the respondent acknowledge that they caused the harm, but because of concerns for litigation outside of our process and to encourage students to feel safe enough to participate in the process, we have diced it out with some very specific language that I will read to you as soon as I bring it up. I just had it. One sec. It says, well, I read it to you earlier. It was on a slide. It says, adaptable resolution is generally designed to allow a respondent to acknowledge harm and accept responsibility for repairing harm to the extent possible experienced by the claimant. But it doesn't actually say that they're taking responsibility for having caused harm. So we have a lot of creativity in the language that we're using.
Sure, and that's very similar to our process.
Chelsea, did you want to add?
It's just very similar to ours, and it's and or, right? And words matter. It's the respondent participating in this is acknowledging responsibility and or the harm that's caused. And so we also have a section where they sign their initials of stating that this does not indicate that a violation of a policy has been engaged upon, but rather, because we're not doing an investigation and we can't make those determinations, but we also have a separate sentence that explicates that out. And I know that there's a question here about the breach of that informal resolution. That's probably a good segue there, that they're also signing, at least for our process, for the respondent of acknowledging that if I'm stating that I'm going to participate in this, I'm agreeing to participate in all components outlined on this contract. And if I fail to do so, I will be potentially charged with failure to comply with a college directive under the Title IX policy, where they'd receive punitive sanctions. So this is not a get out of jail free card, but rather I'm willing to engage in this. But if we don't, then we're going to charge you with failure to comply because you did agree and you've signed, and again, having some type of accountability associated with that.
So here's a question that gets to the fundamentals of the regulation relationship between the formal process and the informal process. If a respondent agrees through an informal resolution process to leave campus for a semester as essentially part of the agreement, can that be done through informal resolution, or would they have to go through a formal process with all the procedural rights there in order for that to happen?
Jeff, this is Megan. I can jump in on just the regulation piece, which says that under the regulation, someone can agree up till expulsion from the school. So I would say you could go through the informal process and leave for a semester, certainly. I think it's permissive under the regulations.
I agree.
But I would also mention that there's definitely a tendency to believe that the full investigation process is the way to go, and that this informal process, while permitted, is not the default position. So you should be defaulting towards investigation.
and to the extent we have to use default language, the regulations, the preamble suggest that. But I would submit we don't have to use default language one way or the other because both options are available to us.
Mm-hmm.
Well, this has been a terrific discussion. We've only had an hour. It's gone by so quickly. I want to thank Megan, Chelsea, and Carrie for taking the time to speak with us today. On behalf of the UVM Continuing Distance Education Division and the Legal Issues in Higher Education program, we very much want to thank you for being with us. We want to thank all those who've logged in to participate and ask the great questions. I would say if anyone didn't have their question answered, send it along and send it to our speakers. I'm sure they'd be happy to respond. We have another session next week. It's going to be on the 12th at 3 o'clock. I'm going to be talking with Margie Fisher, who's the Title IX coordinator at Columbia University, regarding training requirements under the new regs and best practices and promising practices for effectuating those requirements and moving forward with those issues post implementation of the new regs, and it's something that we're going to be definitely engaging with after that. Thank you to everyone who makes this series possible at UVM and elsewise, particularly our speakers today. And thank you, obviously, audience, for joining us. We really do appreciate your participation. A recording of the session will be sent out to everyone who registered, along with an evaluation that we'd really ask you to complete about today's webinar. With that, we're done. Thank you. I hope you all have a wonderful rest of your day. Take care.
Thank you.